Leonard Lapham?
Yes, ma'am. I'm strictly observing, and they invited me to a breakout room earlier, but I didn't know if that would be improper, and so I left the meeting.
Okay, so what are you what are you observing as a friend, or you're observing for what are you talking? What type of observer are you, please?
Your Honor, I'm observing as a significant other of one of the parties involved.
Okay, so you have a dog with this, so you're yeah, yes sir, yes sir. You could obviously, this is open court. You can always be in here. You can be on Zoom. You can be on YouTube if you want to. But yeah, but as far as going in the breakout rooms, like I say, he's here with a party. So that's and sir, if you do plan on testifying, we need to know that ahead of time because you're not allowed to be in you're not allowed to be in the hearing if you're going to be giving testimony in that hearing. All right.
Yes, sir. I understand that.
Okay, but yeah, you're allowed to be here in the main room. That's not a problem. We have that happen all the time.
The state is asking for both final order today and also for the court to make the findings and orders that the district court judge wanted regards to Texas Family Code section 107.023. And if we look at that, look at subsection B, the court shall, number one, determine the fees, costs, and expenses of an amicus attorney ad litem, or a guardian ad litem by reference to the reasonable and customary fees for similar services in the county or jurisdiction. Number two, order a reasonable cost deposit to be made at the time the court makes the appointment. And number three, before the final hearing, order an additional amount to be paid to the credit of a trust account for the use and benefit of the amicus attorney ad litem, or guardian ad litem. So the state asks the court to make those findings and orders, although I'll defer to you on how exactly to do that. State is also asking for a final order, and the state understands that Ms. Kuzak and Ms. Johnson are not opposed to that. The temporary order, Your Honor, it has everything financially the state is interested in that we would like. Number one, it has health insurance through Miss Johnson. Actual cost her of $209 per month, and she and Mr. Flores was ordered to pay as cash medical support $209 each month, beginning October 1st, 2025. It has dental insurance through Miss Johnson. Actual cost of $23 per month. And with that same amount for the cash dental starting October 1st, 2025 per month. It has current child support of $960 that started that same day, October 1st, 2025. It did retroactive child support between November 1st, 2023 and September 4th, 2025 in the amount of $22,096.89, with a repayment of $160 each month.
So 116 or 160, I'm sorry.
160, Your Honor. Each month beginning October 1st, 2025. And of course, for both the current child support and the retroactive support, those numbers will change over time. State understands that there is 2 children in this case, and then I believe 3 children out. That Mr. Flores has. Yes. And then state also asked the court to continue the non-disclosure finding for Miss Johnson. State defers to you on the family violence and family violence finding that was made. Visitation, custody. I will say, Your Honor, that besides the family violence finding, you did in the temporary order make Miss Johnson as the sole managing servitor with Mr. Flores as possessory, but with no rights until further order of the court. And then holding in abeyance any visitation for him. And it looks like there was no geographic restriction. And the state also asked the court to apportion court costs as well. State does not believe Mr. Flores has any military or police or firefighter background. And I think That's it, Your Honor.
All right, thank you. Ms. Kuzak.
Thank you, Judge. I believe I was not here on the temporary orders hearing, but I believe at the temporary orders hearing, evidence was presented that supports all of those money issues. And I am not opposed to that. So I would just ask the court to take judicial notice of that information so that we can lock in the financials as a final order. I can, when I call Ms. Johnson as a witness, I can ask her about some of the domestic violence issues, but I'll suggest that the evidence will show that there have been some domestic violence issues. The reason this has been reset, aside from going to the district court to deal with all of this stuff with the fees, the other reason it's been reset is because Mr. Flores has a pending misdemeanor charge for assault family violence, and it involves Ms. Johnson. It's a case out of 2023. But this is one of those ones we've reset it a few times. We thought maybe we would be on the other side of a plea if we set it for today, but as Ms. Johnson has discovered and I have discovered, it got reset to the 20th. And if we reset it another day, I have no confidence that there's not going to be another, motion for continuance. What I could do, Judge, is I could ask Ms. Johnson about the underlying issues and see if the testimony will support that there's been a pattern of child neglect or family violence where we could just lock this in. I believe the court traditionally wants us to get a copy of like the plea paperwork or whatever that says what the terms and restrictions are. For example, if he is prohibited from having contact with the victim and the victim's family or something like that, that would obviously change the visitation. But I think we could get around that by just having language in the order that says if there are terms on any plea paperwork out of cause number 23 CCR blah blah blah, that those orders take precedence and this visitation is abated, pending basically to be in compliance with that other order. But I would ask the court to appoint the mother as sole managing conservator, father as possessory conservator. I have not met with father. I have reached out by email and by phone. He has also been CC'd on all of those district court coordinations on the hearings. His email has been CC'd on all of those, and we have not heard anything from him. So I don't know if he doesn't check his email or if he is, disregarding the case. I don't know. So there is no evidence to contradict the family violence is what I would offer to the court and see if we can try to lock this down. As far as visitation, I spoke with Ms. Johnson yesterday. I can go through, we both have put together what we think is a good step up visitation. When I say step up, not leading to standard yet, but starting with some video visitation as step one, and then supervised visitation as step two, and then day visit only for a couple hours or whatever on Sundays with a meetup at a police station. I would just ask for firm start and stop times for any day visits, so that there's no confusion on when the kids need to be returned. And then non-disclosure, I agree with that. Ms. Johnson can provide some testimony about concerns she has about him showing up at her house, where she's had to get law enforcement involved. As far as the fees go, Judge, setting aside those other issues, I think it's clear that 107.023 does say that attorneys are entitled to compensation and that judges must apportion those costs. And of course, the underlying reason for that is to make sure that attorneys are not appointed and then judges don't assess costs. So I do believe that there is some sort of assigning of financial responsibility. But in this case, traditionally that involves a case like at the district court where you have a petitioner who maybe wants to change custody and wants someone to talk to the kids, and that petitioner requests an ad litem or requests an amicus or guardian ad litem or something like that. And in that case, it is certainly fair if the parties have requested that for the parties to have to pay. And of course, it says that it's based upon the rates in that going area, in that locality. Obviously, the rates that are involved in the 4D court are not up to that because of the policy reasons behind it. And of course, I'm okay with that as well. But I do think that the court has the ability to determine indigency. And then if the court can determine that there's indigency, then I think that the court has the ability to follow whatever the locality, the presiding judge, the county budget, whatever they decide to do on those fees. I believe that that's within the discretion of the court. I don't know if this is something that requires further briefing or something. If that, I don't, not sure what that would end up.
Well, I may have you looking into that, but I've already looked into that myself, and I've always had some information sent to me by the presiding judge. Sorry, well, I just love this stuff. Judge Waldrop's office sent me some information about that, and along with that, with the necessity of perhaps having to do an affidavit of inability to pay costs as part of the deal. But yeah, the Supreme Court of the State of Texas has said definitely we still have that power to do such. So anyway, let's not get into the weeds and too far into the weeds on this one. But for right now, let's go ahead and see what we can finish up for the day. I was going to ask you whether or not Dad has a court-appointed counsel, or does he have a retained counsel? Because he's got court-appointed counsel, there's probably a chance he already has an affidavit on file of inability to pay costs, and we have to have Mom do her own, and then that way the court can go ahead and apply it as the court sees fit, with guidance from the county, from the district judges on what they want us to do going forward. So anyway. But let's like I said, let's not get too far out in the weeds. Let's go ahead and try to wrap this up. And then, like I said, I'll have you looking to see whether or not he's got an affidavit out there. And then if we necessarily have Mom do one, and we'll take it from there. So is there anything else in your opening argument you'd like to make at this time, Ms. Kuzak?
No, Your Honor, but I do believe that he has appointed counsel.
Your Honor, I can tell you who's appointed counsel, at least on the assault causes bodily injury felony number 1.
So, all right. So he's been found to be injured and it wasn't entitled to court appointed counsel. Okay, you may have to do another one, but I've also got those forms downloaded from different counties across the state. I know we got one for a criminal, but this is the first time this come up, so we may have to use the criminal one or a hybrid version of what the other counties use to do this. All right, but yeah, I'm in possession of those, and I'll see about getting those out also. So anything else at this time, Ms. Kuzak?
No, Your Honor.
All right. Anything else, Mr. Welch, you want to add for the opening? As you can see, where we're probably going to go with this, it looks like we'll be able to wrap up the order today, but doing everything with the cost and the payment and all that, I'm gonna have to set that for another hearing, a subsequent hearing after this, to get that on the record and get that taken care of. So, anything else you want to add at this time, then, Mr. Welch?
So Your Honor, if you're not wanting to finalize today,
I'm thinking about finalizing the order for between the parties today, but finalizing the circumstances, getting setting up a payment, deposits, all that. I'm looking at maybe setting that out for another day, sir.
I think I understand what you want to do, Your Honor. I mean, so I guess you would want it because typically, Your Honor, there's one final order with everything taken care of. I mean, I think it might be safer, Your Honor, if we do like a further temp if you do want to change something to that temporary order to a further temp. And then when we get the fees done, we have one final order with all that in there.
But there's not a reason we can do it different as a separate fee order, sir. Again, that the fee order has absolutely nothing to do with these people going forward as far as their case is concerned.
I
And
guess
Judge,
that will be fine, Your Honor, I guess.
Ms.
I would
Kuzak?
just like to add, we have Ms. Johnson here. We could ask her some basic indigency questions. And then if we're able to, what we could do is on the order, it could say we had a final hearing on 2/12/2026, and this was entered, and then on the have a separate date on there, but all in the same paper order. But that way Ms. Johnson would not have to come back and miss work again.
All right, then that'll work. And again, like I say, we could just really take it down to advisement, circulate stuff that we need as far as those other items concerned, because again, those really don't have an impact on her, except if I made her pay for this stuff. So
Right,
anyway, so
right.
let's go ahead. So we can go ahead and get to, and when you're questioning her, you can go ahead and ask her about her income information, how much dad has been paying, what kind of assets he has as far as retirement, and I'll expand on that as necessary. Instead of having to fill out the written form, we can just do it live like that. All right. So
Thank
Mr.
you,
Welch,
Judge.
I'm going to try to wrap this thing up, and then, like I say, do the rest of the part dealing with the fees under advisement and the court rendering a separate, rendering a ruling, and that ruling can be included in the final order. All right.
That will work, Your Honor, I think.
All right. So at this time, it's Miss Johnson, correct?
Yes, sir.
All right, Miss Johnson, if you can, turn on your video for a moment and raise your right hand. And if you can't, just go ahead and raise your right hand. There you go, ma'am. Thank you. Ma'am, do you solemnly swear or affirm your testimony going to give here today is the truth, the whole truth, and nothing but the truth will help you?
Yes.
All right, thank you very much, ma'am. You're officially under oath. At this time, I'll go ahead and let the state call you as a witness, then have Ms. Kuzak follow up with her request for testimony, and we'll take it from there. Thank you. Mr. Welch, you may proceed.
Thank you, Your Honor. State calls Courtney Johnson. What is your full name?
Courtney Page Johnson.
Your Honor, was she put under oath? I don't remember.
Yes, I did. Just put her in oath.
All right.
Yeah.
So what are the full names of children in this case?
It's Malachi Adonis Flores and Masai Alexander Flores.
And when was Malachi born?
December 24th, 2022.
And so how old is he?
A little over 3 years.
And then Adonis, when was he born?
Malachi Adonis, that's Malachi.
No, I wrote. All right.
Masai.
Yes, when was Messiah born then?
September 12th of 23.
And how old is he?
About 2.5 years old.
So do you have any objections to the court making all the financials, the child support, medical support, dental support, retroactive child support finalized today?
And no, I agree with everything as far as that.
And are you okay with the court continuing that non-disclosure finding?
That's fine.
Has Mr. Flores ever been in the military, firefighter, police officer?
No.
Pass a witness.
Thank you.
Ms. Kuzak, you're a witness. Thank you.
Thanks, Judge. Ms. Johnson, as far as, let's go ahead and talk about the money issue first. What we're talking about is assessment of fees. You probably, we've had this kind of side issue kind of lurking in your case dealing with the fees issue. So, in determining whether the parties can pay for attorney's fees, what do you do for a living, and what is your approximate income?
So I work I work at regional finance. My monthly income is, I want to say about 49 gross.
Okay, so that's before taxes.
Mhm.
And then out of that, taxes come out, and then you also pay for the kids' health insurance, right?
Yes, ma'am.
And then how much are those costs?
It's about, for the medical, it's about 200, a little over 200 a month.
Okay, and then you also have, I'm sure you have a 3-year-old and a 2-year-old, so you have daycare costs where they're still pretty substantial, correct? Or do you?
Yes, I actually, my grandma watches them, but I do give her money for that.
How much do you think you kind of average on that? Or how much, what is your agreement to pay her?
There's not really an agreement. I just give her what I can here and there because again, I'm only one person. I would say maybe 200 a month. If that's, yeah.
And do you own a car?
I am still paying on it. Yes, ma'am.
Okay. Is it just one vehicle?
Yes.
Okay. So do you have any other cars, trucks, boats, motorcycles, RVs, timeshares, trailers, businesses, houses, or land? Anything that you could sell to pay fees?
No, ma'am.
Okay. You currently have an order, a temporary order that allows you to receive supports. Have you received any support?
No, not at all.
Um, and then, so you also don't have any titled property like a house or land that you could borrow money using as collateral, other than the car that you use to get you back and forth from work and to go to the grocery store, right?
Yeah, I have nothing else. Nothing.
So moving on to the other court issues in this, are you asking the court to appoint you as sole managing conservator?
Yes.
Okay, we talked about the issue of joint managing conservatorship, and we've talked about what happens when there's an allegation of family violence, correct?
Yes, ma'am.
Is there currently a criminal case pending in Bell County against Mr. Flores?
Yes, ma'am.
Okay, and I'm sure you probably don't know the full number, but is it a 23, like a 2023 case?
Yes, ma'am. I was pregnant with Messera when it happened.
Okay, so it's 23 CCR 04647. And so are you did they inform you about the status of what's happening, or do you have to go find out for yourself?
So I didn't even know it was ongoing still, until our date with the child support got pushed back in October. That's when I had reached out. I had called that number and spoke to somebody, and they told me that he had picked up that other charge with the license invalid thing. So they were put it off again for that.
But as to the allegation of family violence,
Mhm.
that's a case from 2023.
Mhm.
And is that a case that involves you as the alleged victim in the criminal case?
Yes, ma'am.
Okay. We can't really determine obviously guilt or innocence because he's presumed innocent until proven guilty. But we can present evidence to the judge as to your side of the story.
Okay.
So this happened in August of 23, correct?
Yes, ma'am.
And were you pregnant at the time?
Yes.
How pregnant were you? It was August.
Yes. And I wasn't due to have him, Messiah, until November 12th, but he ended up coming September 12th.
Okay. So within a month of that incident, correct?
Yes, ma'am.
Okay. So what basically happened?
So really, we were just watching TV in my room. He had a habit of just literally snatching my phone, taking my phone away, trying to go through it. So that's what he did. And in my attempt to take it back, he pushed me, which caused me to fall on my side to the floor. Um, landed on my side, my arm, my stomach. At that point, when I looked at him, I saw past him, and my 12-year-old was actually in the doorway. And I saw him run back to his room, so I got up, and he had called my mom. My mom started calling my phone, which he still had. So she called my son's phone again and he put her on speaker, and she's like, "You need to leave her alone." I called the cops, they'll be there. And at that moment, he just left. He left. The ambulance even came. They had to check my blood pressure. They monitored me for a little bit. They told me if it didn't go down, that they would have to take me to the hospital. But it went down, and they asked me questions about what happened. I spoke to a couple of police officers, and that was that.
Okay. Since that time, there was another incident in April of 2025, correct? Well, not a family violence one, but there was another incident between you and Mr. Flores, correct?
Yes, and that's when I actually called them again because I was scared.
Okay, so I'll go through that in just a minute, but is this also a basis for why you're requesting non-disclosure?
Yes.
Okay, so just basically what happened on April of 2025.
So on that night, he had showed up to my house. It was the Friday, and it was going into Saturday, so it was literally like almost 4 o'clock in the morning. And I was asleep. The babies were asleep in my bed with me, and he started banging on the door, ringing the doorbell. So I checked my cameras because I had cameras out there at the time, and it was him. I had him blocked because we had gotten into it maybe a couple days before that. And I'm talking to him through the camera. I'm like, "You need to leave. You're scaring the kids." At this point, Malachi had woke up crying. And then Demetrius went aside through the side gate, went to the back window, started banging on the window. At this time, my bed was against that window. So he had both the babies scared. Had me scared because I don't know. I'm sorry. And he's like accusing me of having somebody in the house, and it was nobody but me and my kids. But again, he had done that before multiple times before it actually came to this point. And
Okay, go ahead and stop you for a second. So,
Mhm.
so the kids were scared and you were scared. Did you call the police?
Yes, I did. I called 911. I told them what was going on. They said that they would send police officers, that if anything escalated, to call back. So he was just going back and forth to the front door, to the window, to the front door, to the window. Um, I had called his phone, and I told him, "The police are coming. You need to leave me alone." And he's like, "You got somebody in there." By that time, he had took off walking. He didn't drive. I mean, he had to have driven because he lives in Colleen, but he walked up to my house when I saw the cameras. I saw him just walking up my driveway. So when the police got there, I told them, they asked his name, and it's crazy because they were already familiar with Demetrius Flores. So they said they were gonna drive around the neighborhood and look for him because I told them I didn't know what vehicle he was in. I just saw him walking. So literally like 2 minutes after they left, he's back at my house again, doing the same thing, trying to get in the house at this point, which when they walked up, they seen him trying to get into my door. I don't know what he was using, but I heard him trying to open my door. And he just started having a conversation with them. And that's when I let one of them in to speak with me about what was going on. I told them at that point I didn't want him here anymore because that was it. There was so many times that he's done that, and I was just over it. And they told him
And
that. I'm sorry.
that's okay. I have to kind of cut you off periodically.
Mhm.
So they gave him some sort of warning. You and I talked about it. It might have been a criminal trespass warning, but he was told not to come back to your house, right?
Correct, because they said I could call them and they would arrest him.
Okay, since that time, he has not been by your house that you know of, correct?
Not that I know of, no, ma'am.
Okay. So are you asking the court to grant non-disclosure so that if you move, that your contact information does not have to be shared with him?
Correct.
Do you agree to allow some sort of contact information, like an email address, so that you can deal with legal issues or notice issues dealing with the kids?
Yes, that's fine.
And then potentially app close. You and I talked about this. They're starting to charge now. But that was something that we thought might be a good solution as we're maybe dealing with a video, so that he can communicate with you in some way, dealing with the kids, and it's all recorded, correct?
Yes, ma'am.
Okay. So as far as visitation goes, obviously when you have some issues dealing with allegations of family violence, it can be concerning about, what would happen with the kids. You indicated to me that you did not think that he would actively try to harm them, correct?
Correct.
There are sometimes some attention issues and whether or not he's focused on what the kids are doing, but as far as actually harming them, this is more of a domestic violence situation between you and him than between him and the kids, correct?
Correct.
Now, granted, they both were there for both of those occurrences, right? I mean, the
Yes, ma'am.
first one, you were pregnant with the baby, but they were both there at
Mhm.
both. Okay.
Yes, and there was multiple incidents in between that also.
So, but you and I talked about what might be good, a good schedule for visitation.
Mhm.
That it would be 3 steps, potentially, if the court approves this. The first step would be to start with video conferencing.
Yes.
And that's because the kids have not spoken with him since that April 2025 incident, correct?
Yes, ma'am.
Okay, so you feel that if they're able to see him on a screen, that they might kind of warm back up to the idea of a relationship with their dad.
Yes.
Okay, so however many, whatever period of time or however many video conferences, you'd like to start with that as step 1. And then step 2 would be supervised visitation, correct?
Yes, ma'am.
And then that could be based upon or where you choose the supervisor. Currently, you feel that your mom would be okay with that?
Yes, ma'am.
Okay. And that would take place on Sundays potentially, correct?
Yes, ma'am.
And then the third step could be day visits. And when we say day visits, not necessarily, an extended period of time, but maybe like before lunch until after lunch so that he can go take them to, Chuck E. Cheese or whatever he wants to do to play, with them and spend time with them, but on Sundays as well, correct?
Yes, ma'am.
Would you ask that those exchanges for the day visit take place at the police station, the Temple Police Station?
Correct.
And so you live pretty close to the Temple Police Station, correct?
Yes, ma'am.
Okay, and I'm not really familiar with the Temple Police Station. I don't know if there are different locations. Are there different ones, or is there just one main one? Is it downtown?
There's just one main one. They
It's
got
downtown.
auxiliaries at the fire stations, but it's just the main one downtown. That's it.
Thank you, Judge. Okay, and so do you feel that those 3 steps would be a good initial basis to kind of get something to allow him to be able to get back in with the kids?
Yes, ma'am.
Are you asking the court to set that schedule? That we didn't really talk about specific times or anything. Well, speaking of that, on the supervised, one time that I kind of threw out to you would be like Sundays at maybe 10, but that would just maybe be a couple hours, but the day visit could be 10 o'clock until maybe 3 or 4 or something like that. Does that sound appropriate?
Yes, ma'am.
Would you like actually though a firm end time
Yes, I would.
for that?
I'm sorry.
So he has other children, correct?
Yes, ma'am.
Have there been issues with miscommunication, whether it was intentional or unintentional, as to when the kids would be returned?
Yes, ma'am.
And so you're wanting to avoid that by having a specific, like Sunday at whatever time, Sunday at 3 o'clock or Sunday at 2 o'clock.
Yes.
Okay. And I pass the witness, Judge.
All right, thank you very much, Ms. Kuzak. Anything on redirect, Mr. Welch?
No, Your Honor.
All right, any other witnesses at this time, Mr. Welch?
No, Your Honor.
All right, then, Ms. Johnson, I'm looking at going ahead and making this a final order.
Okay.
I'm looking at going ahead and doing the administrative stuff that the state and Ms. Kuzak and I have to deal with separate and apart, but getting that all set up for a final determination. But for right now, you're technically your own legal counsel. You see what everybody's asking for. We're looking at going ahead and making the temporary order final as much as we can. We're looking at going ahead and ordering support as per the temporary order going forward. We're looking at going ahead and setting up a temporary visitation schedule and that going forward, and all the other items that you've testified to that you're in agreement with and that the state and the Adelaide said they wanted to do here today. We're looking at setting up. So is there anything else, ma'am, that you're asking the court to do in your own behalf or the children's behalf?
No, sir.
All right, then, Ms. Kuzak, anything else, ma'am?
Judge, do we need to go over those? Are you going to do a docket entry for the like start and stop times and all of that? Or are we
Right.
gonna?
Right now, I just wondering if there's anything else you want to bring out in evidence. I'll go ahead and let everybody make their closing statement also. That way I'll write all this
Okay.
down as we're going down. So otherwise, this thing will be a page long and a half. So yeah. So okay.
I have no further witnesses or evidence, Judge.
All right, thank you. All right, so at this time, I'll go ahead and listen to the closing statements. I'll start with you, Mr. Welch, and then go over to the Adelaide, and like I say, we'll wrap this one up. Thank you.
Thank you, Your Honor. So the state does agree with the court. We do want a final order. Regarding the cost issue, as I said at the beginning, Your Honor, the state asked the court to, as the district court judge said, make those findings and orders outlined in Texas Family Code section 107.023, subsection B 1 through 3, determining the fees, costs, expenses, and then ordering a reasonable cost deposit. And then, if needed, the additional amount to be paid to the credit of a trust account for Ms. Kuzak's use. And then, as for the main order, the main part of the order, so state asked the court to continue the child support, cash medical, and cash dental that were in the temporary order. State understands that neither party here is disputing that. And you heard evidence from about it from last time. So as court simply have that in the final order. Ask the court to continue also the retroactive child support judgment and repayment as well. State asks the court to continue the non-disclosure finding. State defers to the court on the custody, visitation, family violence finding issues. I think that's it, Your Honor.
All right, Ms. Kuzak.
Thank you, Judge. I also would like a final order, at least as to the substantive issues on this, and reserving the ad litem amicus guardian ad litem money issue for another day. I'm requesting the court name Ms. Johnson the sole managing conservator, with the father being a possessory conservator. The child support, I'm asking for all of the financials from the temporary order to be made a final order, including the child support, health insurance, dental, retro, all of that. I would also ask the court to take the evidence that Ms. Johnson presented today about her finances. And I don't know if if the court is able to do that, or if we're reserving that issue for the other hearing, but perhaps find that she is indigent as far as being able to pay attorney's fees. Then as far as the visitation, I think probably app close would be appropriate. Videos could be Sundays. Maybe that one could be 12 noon until, you know, however long the kids can handle that, but beginning at 12 noon for either video or phone. And then perhaps I don't know that would be where we do a certain number, but maybe a length of time.
I'm probably looking at a length of time on that one, Ms. Kuzak.
That's kind of what I was.
Because I'm looking at a length of time and also throwing in the proviso that the criminal matter would have to be taken care of also. So yeah.
That would be, yeah, so pending resolution on the pending some sort of finding adjudication as to guilt, innocence, and punishment if it's guilt. And then number 2 would be supervised visitation, and that could be Sundays. I think probably we could start with 12 noon as well on that one, because supervised are harder to do for longer periods. Maybe do noon until 2. Then the third step would be day visits, and that one could be a little bit broader, possibly, and again on Sundays, but 10 a.m. until maybe 2 p.m. or 3 or 4 p.m.
Yeah, I'm probably looking at those the what would fall under the second the family code definition of the second and fourth weekends of the month. On those Sundays, that would fall into those and that way, if he as far as those other kids are concerned, he could give these his undivided attention, because those will not be his weekends. All right, so
okay, and then that would be great, Judge. I would ask for a firm end time on that for the reasons that were
right. I was thinking either noon to 4. Or you were saying earlier 10, but yeah, they're small kids. Let's make it. I was thinking about making it 12 noon to 4 p.m. And the pickup and drop off still at TPD.
Yes, sir. And then language that any terms in any criminal paperwork dealing with these two parties would supersede, obviously, any visitation or contact.
Correct.
So if he is prohibited from having contact with certain people, that he can't use the child support order to try to work around that. And then non-disclosure, Judge, I believe she's already provided.
I'm gonna go ahead and grant that. Yeah, this is you know, one incident. Yeah, you know, people do stupid things one time. When we do it on a consistent basis, I've got to be worried about it. So I'm gonna grant non-disclosure.
That, and then I think email is appropriate though, because then they can communicate, they can send any business back and forth, like, you know, anything dealing with the kids. And then also app close might be appropriate. I don't know what the court has considered doing on these cases.
Yeah, I just had my first one last past weekend, but those parties could well afford the $9 a month. You know, it's not very much. It's cheaper than it's cheaper than Netflix for sure. So yeah, but
right.
Not by much.
Okay.
But
right.
Yeah,
right.
I'm looking at probably going ahead and doing it. Like I said, if we got people who are truly injured, you know, SSI type of people, we're going to have to figure out a way around that one. But for right now, with these two parties, I would probably go ahead and order app close still.
Thank you, Judge. And I believe that's all I have. Thank you.
All right, thank you. All right then, folks, again, what I'm looking at doing, I'm going to go ahead and grant this, the financials of this case. I'm going to go ahead. First off, I'm going to find that they're based on the mother's testimonies, the acts that have been committed by the father against her do amount up to being family violence. And the court will also find that the father has committed family violence against the mother. He has committed family violence against her while she was pregnant, which I'm thinking is a state jail felony. I don't do enough criminal law anymore to know where that falls these days, but yeah, it moves up there. But he was never charged with that, but he is charged with family violence. So he is charged with family violence. It may deal with the pregnancy also. Am I cracking up?
I think it's Miss Kuzak, Your Honor. Something's with her Zoom.
Oh, okay. All right, but anyway, I'll go ahead and I'm granting the non-disclosure. I'm going to go ahead and grant the financials as stated earlier, child support, cash, medical, and the retroactive and the repayment as per the temporary order. I'm going to go ahead and okay, I'm going to go ahead and grant the visitation package as discussed with the Ed Latham. I'm going to go ahead and start out with visitation with the FaceTime type visitation, electronic visitation with Dad on Sundays. And I'll go ahead and I'll make the electronic visitation with him every Sunday. So, but he has to give her at least 24 hours, 70, I'm sorry, let's make it 48 hours advance notice, Friday or the Friday before, that he's actually going to do that he has set up his electronic visitation app close, and that he's going to, and he'll let her know via text on app close that he's going to do that visitation on that coming Sunday. If not, she'll have to be available. But I'm making it at 12 noon. I'm making that just a 12 noon to 1 o'clock deal. I'm sorry, ma'am. Real quick, ma'am. Do you go to church on Sundays?
Not every Sunday.
All right, I tell you what. On his electronic business, I'm gonna move those later in the evening after nap time. So I'm gonna make those that at 5 p.m. to 6 p.m. They're small kids, so if he can keep them online for an hour, hey, good luck with that. But I'll give 5 p.m. to 6 p.m. and I do that every Sunday. But he's got to let you know at least 48 hours in advance that he's going to do that. He's got to do that through app close. I'm going to go ahead and do the and that's going to be the order of the court going forward. I hate, I'm trying to make it where it kind of be enforceable, but until and that's going to be the visitation, and until and I'm going to do that for at least the next the baby's how old now? 2?
It's a 3-year-old and a 2-year-old.
That's what I thought. Okay. So, I'm going to make that his visitation for the entire year of 2026 going forward. Starting January the 1st next year, if he's completed his criminal circumstances with Bell County, and so long as there's no restriction, then we'll go to the break-in visits where he gets to meet with you and the children for 2 hours, and I'm going to do that on the second and see. It's kind of weird, ma'am. It's called under Texas orders as the 1st, 3rd, 5th weekends of the month, 2nd, 4th weekends of the month, but they're based on that Friday before that being the 1st Friday of the month. So so whatever the 2nd Sunday of the month following the 2nd Friday of the month is, and the 4th Sunday of the month starting the 4th Friday that I just went over, then that's going to be his Fridays to actually see the kid. I mean, his Sunday to actually see the kids. So y'all can agree to anything y'all want to above it, different than that. But I'm going to go ahead and set them on those 2nd and 4th Sundays of the month, and we're going to do those. And instead of making it noon, if you go to my good old Baptist church, you're not getting out before noon anyway. So I'll make that visit on those Sundays from 2 p.m. to 4 p.m. All right.
Yes.
And then after he does that visitation, at least let's see, by then everybody will be almost 3 and 3. So if he has to do that, he has to do those visitations for a minimum of 12 times. And after he does those 12 times, then he gets to move to the visitation where he gets them all afternoon on those same Sundays again. That's 2nd and 4th Sundays. He gets to have them from 1 p.m. until 6 till let's make it 5 p.m. It gets dark at 6 these days and during the winter. So I'll go ahead and make that from 1 to 5. So he gets them for 4 hours. And again, exchanges are always going to be at the Temple Police Department. And on all those visitations, he still has to let you know in advance that he's going to pick the kids up or meet with you and the kids, whatever those circumstances are, at least 48 hours ahead of time.
Okay.
All right, that was a lot of convoluted information, and I'll if you have any questions, I'll take those in a moment. I'm going to also go ahead and order that he be responsible for any and all court costs, and including I'm going to go ahead and I'll have the Lapham confirmed with his packet that is in his criminal file that he has been declared to be injured by the state of Texas. So I'm not going to. I won't order him responsible for any ad litem fees and based on that. But I will order him responsible for any and all costs billed by the county on for court costs. And he has until if he's billed, he has until the 31st day of December 2026 to make that payment. All right, everybody. I think I covered everything. Did I miss anything, Mr. Welch? I'll start with you, Ms. Welch. You think I missed anything, and then I'll go to Ms. Kuzak.
Just to make sure I've got it all written down. So all the finances, the child, medical, dental, and retroactive support, they're all approved as in the temporary order. And then you're keeping the family violence finding that was in the temporary order. And then you're putting the parties on app close. You're continuing the non-disclosure finding that was in the temporary order. For visitation, just so that I've got this. So yes, FaceTime or otherwise electronic visitation each Sunday, 5 p.m. to 6 p.m. But needs to give at least 48 hours advance notice through app close, or otherwise that visitation will be waived for the entire year of 2026. And then starting the first of next year, if any criminal orders allow him to do so, he'll you'll be entitled to meet with the children supervised 2 hours. Your Honor, was that on 2 hours of Fridays after the second Sunday and fourth Sunday?
Okay, now what that is, I know that was kind of convoluted. It's on the second and fourth Sundays of the month from I think I said 2 o'clock to 4 o'clock, right? On the second and fourth Sundays, and that's to coincide with the second and fourth Fridays of the month. If the first falls on a Sunday, that's going to mess things up. Okay, well, on those Sundays where it follows the second and the fourth Fridays, then those are his Sundays. Okay.
I think I get it, Your Honor.
Yeah.
We're looking at the Friday, second and fourth Friday, and looking at the Sunday that comes after those.
Yeah. Yeah, because again, the first falls on Sundays and Saturdays. Sometimes that messes everything up. But hopefully, yeah, and that takes care of it. That's the period when he has supervised visits, and he has to do those at least 12 times.
All right,
Judge, may I offer the language of the Sundays following the second and fourth Friday?
Yes, ma'am.
Okay. I'm sorry, Mr. Welch. Go ahead.
Let me write that down.
Sundays following second and fourth Friday.
I got it. So, and then after that, yeah, for 12 times, and then after that, he will get second and fourth Sundays from 1 p.m. to 5 p.m. Is that unsupervised, Your Honor, or supervised?
That's unsupervised. That's for that 4-hour time frame.
And for the supervised times, Your Honor, is that supervised by mom? And if someone she may choose,
or designated agent, yes.
then exchanges at Temple Police Department, and then for all these in-person visits, notice in advance 48 hours. Or otherwise it's waived. And then court costs as billed on or before December 31st, 2026. And then you're keeping the Ms. Johnson being sole managing conservator, with dad as possessory with no rights until further order of the court.
Correct. Again, I don't know what he's going to end up getting as far as the criminal things are concerned.
All right. And then I think I got all that down. And then for Your Honor, and then you'll basically, did you want us to do a final order with all this in there? And then we'll have a separate order later on that just deals with Ms. Kuzak's saying that she had been appointed as attorney ad litem, that, here are the fees for her, who pays for them, and then that she's released.
Right. Well, this time I'll do it on the record. Based on the mother's testimony and the fact that she's received $0 from this gentleman, and we've been doing this for months on months, I'm going to find that based on her current circumstances, that as far as being able to afford court costs and attorney fees, she is legally indigent.
All right. And so,
All right, and then that's part of the record, and now that that's on the record, and that he has been found to be injured on his record, then I can proceed on what I want to do as far as the ad litem's cost is concerned.
all right. And Your Honor, did you want to set up a ruling only hearing for that?
Yeah, we can go ahead and do that. That'll give you time to get up to speed. I didn't mean to ambush you on this because, like I said, I've been running this by Judge Walter's office for about 2 or 3 months now, since December. So I've got a little jump on this. So is there a date, Ms. Kuzak, that you're going to be back on the Zoom, on our Zoom in the next 2 weeks or so? You muted, ma'am.
Thank you, Judge. I'm looking at it right now. I have, well, I do have the afternoon of the 19th, but that's next week. I have March 5th. I have a setting Thursday, March 5th.
Okay, that should be a special setting though, isn't it?
It is at a different time. That's a Lampasas one, but it's 9:30.
Okay.
Oh, I see what you're saying. Okay, so regular docket. Yeah, but I mean, I have some Thursdays open, so I, you know,
All right,
if
since this
there's
is
a time.
this is the, like I said, this is the 12th. So if we were to do this on the, let's see, okay, the 19th is not a special. Okay, all right, I've got. How about the 26th? That's a Thursday, and with a general docket. How's that look? February
I appear to
26th.
be available, Judge.
All right, so just so we're going to fall through the cracks, Mr. Welch, let's go ahead and reset this for that date on the regular docket. All right, 9 a.m.
Indeed, Your Honor.
All right. All right, and is there anything else, folks?
Is there anything that is that for a ruling only and we just appear, or do we need to prepare anything for that? Like,
Okay, I'll
do
tell
you
what,
need anything from us?
let's go ahead and I'm looking at making that a ruling. If somebody needs to get something ahead of time, we can do that. Go ahead and do it. But I was just going to go ahead and do it as the opportunity to do a ruling and perhaps. Okay, well, I'll tell you what. We'll go ahead and listen to any. After everybody does their research, we'll listen to any type of closing, and then I'll make my ruling. Okay. But no matter what, I'll make a ruling at that time after I hear the any other statements either side wishes to make.
Thank you, Judge.
Yeah, because I hadn't had a chance to read that whole Supreme Court case yet, but I will before then. Thank you. And I'll pick that up and try to get that out to both of y'all too. Okay.
Thank you, Judge.
All right. Anything else then, Ms. Kuzak?
No, Your Honor. Thank you.
Mr. Welch?
No, nothing else, Your Honor.
All right. Thank you both very much. And Ms. Johnson, you don't have to be here on that one, but we'll try to make sure and get everything set up. And after I make the final ruling on that, this will be, might want to bifurcate it from the order. I'll see if that's appropriate, but if it's not appropriate, then we'll go ahead and put it in this order itself, Mr. Welch. But for right now, I'm looking at probably bifurcating it if we can, because again, that's just a bunch of gobbledygook that doesn't need to be in their order going forward, dealing with their kids.
I understand, Your Honor, and
Okay.
I think that will probably work. Although I'll talk to my colleagues about
All
it.
right. All right. Well, again, if we need to put it in there because somebody said, no, it's gotta be, we find out, yeah, it has to be in there. We'll put it in there. Not a problem. All right, Ms. Johnson, do you have any questions, ma'am?
No, sir.
All right, then since there's not an order ready, is Ms. Johnson free to go?
Excuse me,
Indeed,
Your Honor.
Yes, ma'am.
Did you say that date was March 26th?
No, I said February 26th.
February 26th. Okay.
February 26th at 9 a.m. It's our general docket.
Yeah.
Okay.
So, Ms. Johnson, I think, well, If I could just briefly just make sure her contact information is updated in our system.
All right, the state's going to need to take it back and break out and confirm your contact information, but after that, you'll be free to go. All right.
Thank you, Your Honor.
All right. Thank you, everybody, very much. Thank you, Ms. Kuzak. Thank you, Mr. Welch. We're off the record.
Thank you, Judge.
The state is requesting a DNA order, but Mr. Munoz has some concerns regarding that issue, Your Honor.
Okay, Mr. Munoz, what's your concerns about having a DNA order, especially when you kind of requested one in your answer, sir?
Hey, sir. I think more so my concern with all the situation is more due to my current status. I'm active duty in the military. I've been next month will make 1 year that I've been away from home, away from my wife, my stepdaughter, and this process. I mean, this case was something that happened. It's already going to be some time ago. It's going to be going on 2 years ago almost, but just more so the fact that a mental and psychological barrier due to Arvallo, Zamzal. I don't know if she ever mentioned to her, I guess her legal or counsel, her advisors, legal advice, attorneys, whoever she spoke to, attorney general. But I mean, I was under the assumption the child is not mine. And when I was under the assumption that it was, multiple attempts were made by myself, by my wife, by my parents due to my presence not being in the state at the time. Because like I said, I've been gone since last year, March. For them to be able to do a DNA on my behalf, or obviously not my wife, but my parents, siblings, there were more than.
No, sir, we're going to use you. Where are you?
I understand. I'm in Oklahoma.
It's not like, yeah, we got labs
No,
in Oklahoma
I understand.
that we can use, sir.
I understand that. It's just more so the fact that I'm concerned that they're just in attempts to gain something due to me being in the military via more than likely insurance benefits, because obviously that was stated in what I was served with in the documents. She was wanting the child on health insurance. I'm assuming she's going to want child support, and I mean I understand responsibility is a responsibility, and that's understandable. But multiple attempts were made prior to this. A while of a sudden now.
Sir, any attempts y'all made outside of court of law, they don't count. Okay. It actually takes a court order to determine paternity when you're not married or y'all have not signed off on an affidavit confirming that y'all are the parents. So it's going to take a court order, and I'm going to have to order DNA testing because that's what everybody wants in this case. If it turns out not to be your child, then you know everything. Then you're out. Okay. But if it turns out to be your child, then yes, sir, that you do have financial responsibilities going forward.
I understand that, sir. But like I was saying, to just do the psychological, like me being away, when I get out of advanced individual training here in Oklahoma, because like I said, I've been gone for a year. The likelihood of me getting sent to Germany or Korea is highly likely. So I will not be home. I will not be in Belton. I will not be in Bell County for an extended period of time. This child will likely never see me, whether I am the father or not. And I mean, regarding this case, I mean, me and my wife, it's a little difficult for me. Like I told the lady I spoke with just in the other room.
Yes, sir.
I'm not like right now. This is me being on the phone right now is causing an issue with my current training. My command is kind of had to be briefed. I've had to follow a whole chain of command just in order to be on this phone call at this time, and it's causing an issue where I'm missing important things right now. And I'm not saying it's a waste of time by any means, but I'm just trying to say that on me and my wife's behalf, because she is my power of attorney, if she can handle things like
No, sir,
involving the case.
No, sir, she's not licensed. She has to be a licensed attorney in the state of Texas before she can come in and do anything in your behalf, sir. All right. She cannot practice law unless she's a lawyer.
Is there some story? Okay, so if I'm I guess I'm just, because I don't have a lawyer, so that would be me in this case.
You can hire a lawyer, you can represent yourself, but you can't have a lay person represent you, sir. Sorry.
Is there some sort of law or something with that I can look up? Or statute?
Sir, I can't tell you how to practice law, but I'll let you know you can. A non-lawyer cannot practice in a court in the state of Texas unless they're representing themselves, sir. You can always represent yourself, but you cannot represent a third party, even your wife or spouse.
Okay, so even if I'm completely unavailable to be like, because like I said, most of the
Sir,
times if you
first
try
off,
to,
let's just find out whether or not the child is yours. And if you're unavailable, you're unavailable. Okay. It is what it is. But the bottom line is I'm going to go ahead and order DNA testing in this matter. And it's up to you to make sure it gets done. Because otherwise, if you don't take care of that, sir, then the court has the option of just going on and declaring that you're the father without the DNA test. So you got to cooperate with doing it, sir.
well, I understand if the
The
state,
circumstances are the circumstances. I can't change that. And you're in the military. You're not in Texas at this point, but right now the jurisdiction with this matter is in the state of Texas because the child's in the state of Texas, and we need to find out whether or not you're the father.
I understand, sir. So involving this case, like, would I hear back when I hear, is there going to be another hearing after this once the DNA
Once you
testing
get
is
the DNA
completed?
test back, sir, there'll be another hearing setting this matter up for final hearing. If the DNA test comes back positive, it's going to be another hearing to set this thing up for final. And if it comes back negative, there'll be a hearing that they declare that you're not the biological father and dismiss the lawsuit against you.
Okay, I understand. So at one point during I guess any of these hearings, whether it be now or in the future, can I go through the process? Because me and my wife had been speaking, like I was under the assumption she would be able to speak on my behalf when I'm away, but apparently I was wrong. So we were wanting to sign our rights. I mean, if the child is mine away to the mother.
No, you can't do that, sir.
How can I not do that, sir, if you don't mind me asking?
Because, sir, here's the deal. It's considered to be in the child's best interest that parents are parents. And for another parent to discharge their parental duties, the state of Texas is going to look for someone to step in and take their place. We don't want children running around out there not being with parents. If somebody comes in and wants to adopt your child with her, that's fine. But we do not let people, get away from their parental duties as per the laws of the state of Texas, and it's that child's right to receive from you. The only thing I can't order you to be a dad. I can't order you to do visitation. I can't order you to do other things, but I can order child support, and I can court order visitation if you want to do it. But I got to order child support. I got to order dental insurance, and I've got to order medical insurance, and that's all from straight out of the Texas Family Code. You probably really need to do it. You really do need to talk to a Texas attorney, sir.
I understand, sir, but as you can see, there's not enough time for that. I don't have time for that. I barely had time to make a phone call today, so it's very difficult.
Sir,
I understand.
Okay, well, I understand you might be busy. Things happen, but it's as far as military people are concerned. So yeah.
Well, yeah, it's for our country and all, sir. So, but I get it. I understand where you're coming from.
All right, but again, sir, the rule, the normal is that one parent is not terminated unless there's a legal reason to terminate, abuse, that sort of thing, or there's somebody else is waiting in the wings to take their place.
I'm sure there is. I already know there is, but like I said, I don't dabble into my past, but I know there is. But it's fine.
Sir, I'm getting ready to end this one, sir, because again, this is not everything so far in this hearing has been about 2% that's been legal information, and everything else is just what you requested. And right now, I just need to get my DNA test ordered and find out whether or not you're dead. And then if you can have your wife go down and talk to a lawyer for you, but the lawyer let her know that you would be declined and not her eventually. But the bottom line is, yeah, that's up to y'all to see how y'all want to handle all this.
Yes, sir.
So, Mr. Munoz, I'm going to order DNA testing. Both sides are asking for it, and if it comes back negative, then then we'll dismiss as to you. If it comes back positive, then we'll have to go forward with an order that takes care of all aspects of this child financially and visitation-wise. If you want to do your visitation, that's fine. If you don't, that's fine also. But the part of the court order that is enforceable is the part about the child support, the medical insurance, and the dental insurance, sir.
Yes, sir.
All right. Anything else? Any other questions?
Your
No,
Honor,
sir.
I have one question for Mr. Munoz. When will you be back in Texas so that if you need to, you can do a walk-in for the DNA testing?
I will be back in Texas maybe early June, but that's to move my belongings to wherever I will be stationed. That's not an extended period of time. That is just time for me to move.
Okay. Well, we'll have to do the draw in Oklahoma. So yeah. All right, just which facility are you? You gonna be at this same facility in Oklahoma, sir, going for until June, or what are you talking about?
Until June, I will be at Fort Sill, Oklahoma. As of now, there's my current orders do not state where I'll be definitively, but
Yeah.
like I said, more the likelihood of it being Germany or Korea are very high.
Okay, well, we're gonna get it done long before then. We'll set up something at Fort Sill. It's not the first time I've had to do a DNA test for someone stationed at Fort Sill, so that's not a problem. It's just the other way is quick. If you're local, it'll be a lot quicker.
Should
Yes,
we
sir.
also get a reset, Your Honor?
Yeah, let's go ahead. What reset date would the state be looking at?
I'm not exactly sure. Probably like 3 months, I suppose, because
I
of
was
the
looking, I was
DNA
thinking
testing.
April, and you know, he's in Fort Sill. It's not that far away, but yeah, it is. The logistics, you know, it's up to y'all. You know, go ahead and get that set up. So this is so the 30 days out is March, 60 is the April. So May is a good 90 days out. So let's look at something in early May, and that way, well, mid-May, and that way we get almost the full 90 days, and he's still supposed to be there at least through the end of May anyway. So.
Looks like we have May 12th and May 14th, Your Honor, as well as May 5th.
All right, sir. Well, what days are those on? The 12th and the 14th are obviously a Tuesday and a Thursday, right? 5th is a Tuesday, okay. And the 12th, 7 days later, so, you know, so that's a Tuesday. So, and the 14th is a Thursday. Got it. So, sir, if you had to do a Tuesday or a Thursday and in May, which one would you want for your reset date?
Thursday, more than likely, sir.
All right, then. So the 14th.
Yes, sir.
All right. All right, sir. The state will go ahead and see about setting that up and getting you set up at a facility near Fort Sill. Again, sir, you sound like you're a busy man, but here's the deal. I will let you know that they'll set this up, and they'll set it up at least 3 times. But if you miss 3 appointments, they'll come back to me, and under Texas law, I can make a declaration that you are the parent if you do not. If I get an affidavit back from the facility up there that says you had failed to comply with taking the DNA test, so I don't have to have a DNA test to determine if you are the father, if that's the case. So again, that's straight out Texas law. But the bottom line is, we're gonna give you the opportunity to make sure you when you make those make an appointment, make sure you can attend that the Army's not going to mess with you or interfere with that in any manner, way, shape, or form, duty or duty, sir. Okay.
So am I going to receive I guess just a letter or something stating where I will need to go and those
Yes,
appointments?
sir.
Or
They'll send you the information. They'll send it attached to an email, or have everything is attached to emails these days, and you will get that information.
Your Honor, we could do the DNA order and then he could sign off on it in the Zoom, Your Honor.
All right, so you're gonna do that right now.
Yes,
All
Your
right,
Honor.
okay, so, sir, they're gonna go ahead and get you this, get a copy of the DNA order, but the actual appointment, they will send you that information, and again, they'll usually do it electronically. So make sure they have a correct, make sure you have they have your information so they can send you the email or the text message. Okay.
Yes, sir.
All right. All right, everybody, let's go ahead and like I say, I'll go ahead and do the reset. I'm on the DNA test, and I'll see everybody in May. Thank you. We're off the record.
Our last substantive hearing was in October. In October, Your Honor, you I believe had a talked with the children in chambers at that same time as well, and so you had basically reset the case for a November 25th date to try to order entry, but we didn't know at the time, Your Honor, November 25th could not work for the court. So basically the case kind of floated around. Eventually it got set for January to get that recording. You gave it to me with it. And after talking to my colleagues and Miss San Miguel, who also got a copy of the recording, I drafted an order, a proposed order. Miss Messera, the custodial parent, Miss San Miguel, they all signed. Mr. Detrick, he opened it. I say understands that he viewed it. He has not signed. Say understands that he has issues with the order. And the state's asking the court to confirm it as final so that if Mr. Detrick wants to do something later on to change your rulings, that's on him, Your Honor.
All right. All right, then. So is you're opening telling me Mr. Detrick has substantive problems, not legal problems with the order, is your understanding?
I didn't go in depth with his problems, Your Honor.
Okay.
I
Well,
believe
I'll let him tell me what he thinks is wrong or why I should not enter it. So again, I'll let him do that. I won't put his words in your mouth. Then don't worry about it. Anything else, sir?
I don't think so, Your Honor. That's it.
All right, thank you. Okay, Ms. San Miguel.
I don't have any issues to bring up, but I am in agreement with the order that was provided and signed by Mr. Welch.
All right, then, Miss Messera, I'm gonna mispronounce your name. One final time, Miss Messera. Was there any objection, any problems with the orders as is, ma'am?
No, sir. I'm in agreement with it.
All right, Mr. Detrick, so you're the one. So, sir, tell me what objections you have to the court entering that order as is.
I have no visitation. My children have expressed to me that they would like to see me and visit me. And I don't understand why I have no visitation. And we were supposed to go in November and revise the whole order. You're to the children after talking to me on video chats what they would like.
All right, so here's the deal. I know you're not a lawyer, sir. And again, let me get back to the current order. The court will take judicial notice of the entire court file, including the temporary order that was done back in April of last year. At that time, the court had a hearing and did find that it was in the best interest of the children that Miss Messera be named the sole managing conservator of the children. The court did at that temporary order made a finding of family violence in this case against Mr. Detrick, and based on that, court did limit access, visitation, and so forth and so on. Court will further note that in the final order of this that's been submitted to the court based on the September hearing or the hearing earlier, that the same family violence finding is there, that it's been expanded to include counseling for the kids and restricted access by the father and restricted rights by the father based on that family violence finding. And again, that's pretty much in conformity with the temporary order. So at this time, Mr. Detrick, with that family violence finding, the state's asking me to go ahead and enter the order as per what the court has made as far as the ruling concerned. What the children may want, they're children. They're not legally, I'm not legally obligated to follow anything they request, and I have not gotten that information from, in their behalf. The guardian ad litem for them is in agreement with the order being as is. So, sir, what is the legal reason why you feel like the court should not sign off on this order?
What do you mean legal reason?
Here's the deal, sir. This is a motion to enter order. I know you're not a lawyer, but the lawyers here are saying they want me to go ahead and sign off on this order, and they're in agreement that this is what the court has ordered and that I should sign off on it. What is your legal reason for me not signing off on it, sir? Because again, it just can't be because the kids want to see me and that sort of thing. I have to have a legal reason not to enter the order as is based on what the court has ruled.
Well, did the kids ever get counseling to talk to you about what they talked to in counseling?
Again, sir, that's not a legal, that's a question, not a legal reason. Why should I not sign this order, sir?
I don't have a legal reason why. Why would there be a legal reason why? I'm not understanding.
Again, sir, I know you're not a lawyer, sir, but everybody else is saying this is what I should. Everybody else is in agreement with this, and this is being the ruling of the court, and this is what I'm looking at signing off on, sir. Unless you've got a legal reason for me not to do it.
I have no legal reasons. What legal reason? I don't understand.
Well, again, sir, I can't give you 3 years of law school and a bar exam in the next few minutes, sir. So with the, I'm looking at going ahead and granting the order, entry of the order at this time, sir. Is there anything else then at this point, Mr. Welch?
No, Your Honor. Miss Walker will have it e-filed, or yeah, she'll have it e-filed.
All right. And Ms. San Miguel, anything else, ma'am? Okay, you muted, ma'am.
No, Your Honor. Sorry.
All right, Ms. Messera, anything else, ma'am?
Your Honor, can I talk to you?
Sir, you are talking to me, and if you talk about it in private, no, sir, you cannot. That's not allowed.
I cannot request an ex parte.
No, sir, you can't ask me to. You can't ex parte a judge, sir. No, sir. You can request it, but I cannot grant it, sir. I'm not allowed to talk to you in private.
So how do I go about appealing and getting transcripts for the last, all the court dates that we've had?
Yes, sir. I can't tell you how to practice law, sir. Either you got to hire a lawyer to do it for you, or you got to figure out how to do it yourself, sir. And again, you'll be held to the same level as your attorney. Just like you had to give me a legal reason not to sign off on this order, you have to make any and all requests be in conformity with the Texas Rules of Civil Procedure, the Texas Family Code, and the Texas Rules of Evidence. Those are the big three. So, but you have the absolute right to appeal anything I do here today, sir. You have the absolute right to de novo anything we do here today, but it's left up to you to do it and do it properly, or hire somebody to do it for you.
None of this was done right. The kids were supposed to have counseling, and you were supposed to talk to them later on the 25th so that you could see if I have visitation, if they want to see me, and nothing has been. This is all wrong. The children want to see me.
Again, sir, they are not adults. They do not get to make their own legal decisions at this point. This is the request of everyone else, and including the attorney, the guardian ad litem for the kids. I'm signing off on the order, sir. You have the right to de novo and appeal anything I do here to the district court or to the Court of Appeals in Austin. It's left up to you how you want to try to handle it, sir. Anyway, the court's granted the request to sign off on the order, and we're off the record. Thank you.
Thank you, Your Honor. Ms. Messera, Mr. Detrick, Ms. San Miguel, y'all are free to leave. Ms. San Miguel, I don't think you have any other cases today, unless I'm mistaken.
No, that is all. Thank you.
Thank you all. Ms. Messera, Mr. Detrick, you can leave. So
The state has a U.S. petition on file. We're asking that you take judicial notice of both the petition and the service of Mr. Aubrey, but I guess you have on both. But in the petition, there is an acknowledgement of paternity signed by Mr. Aubrey Jr. and Ms. Fitcher.
Okay. All right, court. Well, like I say, I'll confirm that in just a moment, but I'll take your word for it that there is an AOP. And was it a state of Texas one, or was it a foreign one?
It was a 4-1, I think, Your Honor.
All right, then.
It's at the bottom, though. Or
Okay, this looks like this might be an AOP. Let's see what this is. Yes, this is yeah, the court will take judicial notice of the court, and there is a affidavit. They call it an affidavit. They call this. It's an acknowledgement of parentage. Yeah, so this is an acknowledgement of parentage in this matter, and it looks like it's from the state of Washington. So you may proceed. Thank you.
yes, Your Honor. I'll call Molly Serrels.
Great. All right, Ms. Serrels, I'm sorry, I didn't have a chance to swear you or the mom in. So at this time, I ask you both to raise your right hands. You both solemnly swear or affirm your testimony don't give here today the truth, the whole truth, and nothing but the truth will help you.
Yes.
Ms. Fisher, you so swear?
Yes, I do.
All right, you're both officially an oath, and the state may proceed.
Ms. Serrels, what is your name?
My name is Molly Serrels,
Who do you work for?
the Office of the Attorney General.
What is your job title?
I'm a child support officer.
What are your job duties?
My duties include conducting detailed investigations to locate absent parents, establishing paternity, filing to enforce court orders for child support and medical support, and responding to customer inquiries and doing wage investigations.
Did you receive specialized training to perform those job duties?
Yes.
What is that specialized training?
I have been trained on using different programs to locate wage information for non-custodial parents.
Have you done wage investigations in this case?
Yes.
What were you able to find?
I was able to find reported wages from 2025 from Q1 through Q4. And there were actually 2 employers for this parent that were reporting in 2025. For Q1, they reported $14,806. For Q2, I found $20,190.40. For Q3, I found $21,868.40, and for Q4, I found $18,690.80.
What is the current child support amount that you calculated?
The current child support amount that I calculated based on this information would be $751 a month.
What amount of other children does Mr. Aubrey have?
I was able to locate 3 other children outside of this case.
Did you find any child support orders that he was ordered to pay on those?
Yes,
Your
ma'am.
case.
On 2 of the 3 children, I found current child support obligations.
Does your current child support amount reflect those other kids?
Yes.
What retroactive support total did you find?
The total amount based off of the wage research I did for retroactive would be $24,048.
How many months did you calculate that for?
I calculated that for 48 months for 4 years.
What repayment amount did you calculate?
$170 a month.
What medical support amount did you calculate?
The child on this case has government medical, so I calculated the support at $71 per month.
I'll pass the witness, Your Honor.
All right, Ms. Fisher, do you have any questions of this CSO?
No, sir.
All right, may the CSO be excused, Ms. Bethlyn?
Yes, Your Honor.
All right, thank you very much, Mr. Serrels, and I will confirm that you are an expert witness and the court has taken the information and placed it in the court file as far as the docket sheet's concerned, and you're free to go. Thank you. All right, you may call your next witness, Ms. Bethlyn.
Yes, Your Honor. The state calls Genevieve Fitcher.
All right, ma'am, say your full name for the record. Do you hear me, ma'am?
What's that, sir?
State your full name for the record, please.
Oh, Genevieve Fitcher.
All right, thank you.
What is the name of the child on this case?
Jayon Aubrey.
How old is Jayon Aubrey?
He's 8 years old.
Who does he live with?
He lives with me, his mother, Genevieve Fitcher.
Who is his father?
Jesse Aubrey.
Is that Jesse Aubrey Jr.?
Yes.
Did you sign the acknowledgement of paternity with Mr. Aubrey Jr.?
Yes, I did.
How is Mr. Aubrey employed?
When
If you
we
know-
were together, he was employed as a wildland firefighter. We haven't had a lot of contact since Jayon was about 2 years old.
What concerns do you have for the child's safety with Mr. Aubrey?
Ms. Bethlyn?
I have no
Ms.
safety concerns.
Okay, I'm sorry. Again, the only thing I can deal with is child support on this. This is not a visitation custody type case. So, ma'am, that jurisdiction falls wherever you and the child live now. But for right now, the only thing I can look at doing is setting up child support, retroactive child support, health insurance, and things like that. So you may proceed, Ms. Fletcher. I'm sorry. I didn't want to
Sorry, Your Honor.
like that.
I was just trying to attempt to show that there's no need for non-disclosure, Your Honor. That's
Oh,
all.
okay. Yeah, okay. All right, you're doing the end around to get there. You know, football season's over with, Miss Bethlyn. Come on, just dribble that ball down the court, okay?
Sorry, Your Honor. I just went to
Basketball
trial
season.
skills. I'm trying to do it properly, Your Honor. Okay.
That's okay.
Okay. Ms. Fisher, in a final order, your address and telephone number can be made public. Do you have any concerns about that?
No,
After Jayon was born, when did you, Mr. Aubrey Jr., and Jayon live together?
we never lived together.
During the time that y'all didn't live together, how many direct cash payments did Mr. Aubrey Jr. pay to you for the support of the children? Or for the child. Sorry, Your Honor.
I think since he was born, he may have given me like $100 or $200, maybe like up to 10 times.
What was the total amount for the last 4 years?
0.
How is the child in this case currently covered under health insurance?
He's covered by the state of Washington, Apple Health, Medicaid.
What health insurance is available for Jayon through your employer?
I am currently on Social Security disability. I was diagnosed with cancer and I'm unemployed at this time.
I'll pass the witness, Your Honor.
All right, ma'am. Is there anything else you think I need to know, ma'am? I'm looking at going ahead, and again, the only thing since this is not a custody type order, this is a U.S. Uniform Interstate Family Support Act petition matter. I'm looking at going ahead and granting the state's request at this time. I'm looking at going ahead and ordering. I'm finding that under Texas law that AOP, that knowledge paternity, is sufficient. That he is the child's biological father, and for that, I'm going to go ahead and order that he be responsible for child support based on the amounts that's set forth by the CSO, child support and cash medical, and cash medical as requested. I'm going to go ahead and grant that based on her calculations. And giving him credit for 3 other children, that's the correct amount of child support. He has had the opportunity to appear in this matter and put forth any defenses or information he wished, but he has failed to do so. So we're doing this in default. I'm going to go ahead and grant the unpaid or retroactive child support for the previous 4 years. And based on your testimony, he received no funds from him in the previous 4 years. So I'm going to go ahead and grant retroactive child support, and order repayment again is calculated by the child support review order. And you say he's a first responder?
Yes, he worked on when we met a federal wildland firefighting crew.
All right, then. Well, I'll waive court costs for the gentleman, but other than that, but the money he owes you and that child going forward. And like I said, and the child support is starting the first day of March. Is that correct, Ms. Bethlyn?
Yes, Your Honor.
All right, so granted. Is there anything else that you have a question about, Ms. Fisher?
No, sir.
All right, Ms. Bethlyn, anything else I need to rule specifically on? Anything else you're asking the court to do here that we didn't cover?
Oh, no non-disclosure, right?
No non-disclosures granted. It's not necessary. Sorry about that. Yeah. Okay. Anything else, ma'am?
No, Your Honor.
All right, then Ms. Fisher free to go, or you want to back and break out?
Break out, Your Honor.
Thank
All right,
you.
ma'am, we're gonna go back and break out. The state's gonna prepare that order and get it to you and try to get you out of here. Thank you very much, and we're off the record.
Appreciate it.
I believe the paternity was already established in the temporary hearing, Your Honor, but we are requesting a final order where the child support remains the same as a temporary order and the medical support remains the same as a temporary order. But we would also like to establish retroactive child support with a repayment amount. And I believe that non-disclosure was already granted in the temporary order. Now, as to the rest of it, I believe the Adelaide could fill you in, Your Honor. Because the state has no position.
Who's here
on this.
today?
Only Ms. Campbell, Your Honor.
All right,
And
thank
of
you.
course the ad litem.
Okay, thank you. Ms. Kuzak?
Thank you, Judge. When I was appointed in June, there was an issue raised, an allegation of drug use, specifically methamphetamine. The father agreed to drug testing, and that since then, that has not happened. So from June, we went to an August hearing. Then there was an October hearing where I sent a Facebook direct message to him asking him to join or to be involved. We reset the case to December. At the December case, we were wanting to finalize, but we had a question about whether he knew about the hearing date or not. So we reset it today to make sure he knew all about it. And so I sent, I had 2 calls. I called him after the hearing, and then he called me back and left 2 messages shortly after the hearing. And then I called him back and spoke with him one-on-one in December. I told him the substance of what we had discussed, that at that time that he was ordered to do drug testing, that visitation was changing because his mother was no longer available to supervise. And so I told him that we had switched it to the Unity Supervision Center. And then he cut me off and said, I'm not driving to Killeen for that. And then I tried to speak with him a little bit about that, but at some point he said, okay, goodbye. And he hung up. So he knew at that point. I sent an email after that confirming everything. So I told him the next hearing, and then I put that date on there, which was today's date and time. I told him that I still needed to meet with him because I had not had a very substantive meeting with him. And I gave him a Zoom date of January 8th. And he did not join the Zoom room on that date. I told him about the drug testing as well. And I put that all in the email. And when I got an email back from him, so I can confirm that he received the email from me that had all of those terms in it. I had a firm date on there for the drug testing. And I have that email as well. I won't necessarily read the whole substance with you, but I went through and outlined all of this. And then again, like I said, he replied. So he has received that notice. Email reply. So I told him that the drug testing was to be at any lab test now. I gave him the street address. I said it was due on or before Saturday, December 27th at 10:30 a.m. I explained that if he did not do the drug test as ordered, that it would be likely be deemed a failed drug test, and that would be taken into consideration when the court makes appropriate orders for visitation. I told him about the visitation and the visitation center and how he could exercise that visitation. And again, about the meeting and the court date. Since that time, he did not join the Zoom room. He has not visited Hilly, and he has not drug tested at any lab test now. So I know that he is also aware of this because I forwarded this to Miss Molina. I don't know if she's printed this or not, but there were 2 text messages that he sent to Miss Campbell. We can go into those in a little bit, but one of those, he was aware of a court date, and he said he was not going to be present. So with all of that in mind, I would like to try to finalize today if I could. What I would be requesting is sole managing conservatorship for Miss Campbell. It was joint managing on temporary. I'm not sure what evidence was presented, on that day, but Ms. Campbell is also, I believe, requesting sole managing conservatorship. We're requesting supervised visitation again because of the reasons we discussed before. There have been several times he's been told about the drug test, and knowing that that is a block for visitation, and that it's still, he has not taken it, I can only presume that there are reasons why, and it has to do with the fact that he may not be successful in this drug testing. So I would like for the supervision to be to continue the supervised visit. The last temporary order could have language that we could pull for Unity Supervision Center. Obviously I would like mom to also be able to, if things change and she has a good supervisor, that she could, it could be at her discretion to choose a different supervisor. That would maybe make things a little bit less clinical for Hilly. But right now, and we'll talk about this with Miss Campbell, that's really our only option. And I think that's it, Judge.
All right, thank you very much. I'll go ahead and let's get Ms. Campbell under oath. Let's get this information officially on the record. And we'll see about finalizing this matter as per the request of the attorneys and the testimony of Ms. Campbell. So at this time, Ms. Campbell, please raise your right hand. All right, ma'am, you solemnly swear or affirm your testimony gonna give here today is the truth, the whole truth, and nothing but the truth, so help you.
I do.
All right, ma'am, you're officially under oath. I'll go ahead and allow the state to call you as a witness. You put your hand down. Please state your full name for the record, ma'am.
Rebecca Campbell.
All right, thank you. You may proceed at this time, Ms. Bexley.
Yes, Your Honor. Who is the child in this case?
Hilly Elledge.
How old is she?
3.
Who is her father?
Michael Bowman.
What is her date of birth? Or I guess the year of her birth and the month. If you don't want to say the whole thing.
July 2022.
Have you, Mr. Bowman, and Hilly ever lived together?
No.
Has Mr. Bowman paid any money for Hilly's support to you?
No.
Do you have any idea what Mr. Bowman's income was at the time from Hilly's birth to the time child support got ordered?
No.
Do you know if Mr. Bowman has any other children?
No. Sorry, just one.
He only has one kid, and that's Hilly, right?
Correct? No other children. Correct.
Okay. I'll pass a witness, Your Honor.
All right, thank you very much. Ms. Kuzak, you're a witness.
Thank you, Judge. Ms. Campbell, at the hearing in July that I was not a part of, an issue was raised about potential methamphetamine use, correct?
Yes.
Okay. And were you present that day for that hearing?
Yes.
Was Mr. Bowman present that day?
Yes.
Did he agree to drug testing?
Yes.
To your knowledge, has he told you that he has tested or that he's clean or anything like that?
He has never said anything about him going and testing. He just will tell me he doesn't do drugs and he's not going to go take a test. He's not going to.
So he, are there other behaviors that you've seen, like where he has been manic?
Yes.
Has he had difficulty getting along with family members?
Yes.
Is he, welcome in his mother's home at this point? To your knowledge?
No, he's
Okay.
not allowed there.
Okay. So do you know if he knows about this hearing date?
Yes, he does.
And how do you know that?
I sent him a text message 2 weeks ago, letting him know the date, the Zoom meeting, ID number, and the time.
Okay. Did you get a response to that?
Yes, he did.
Judge, I have emailed two
I got it.
text messages. Okay, good. Thank you. There's one text message. I'm sorry, let me open it on my computer. Okay, so you told him the court hearing is on February 12th, 2026 at 9 a.m. and you gave the Zoom hearing. So was his response, I'll go ahead and edit it, but F it all, I'm not going to be there?
Yes.
Yes. Okay. Does he feel that you are keeping Hilly from him?
Yes.
And you know that because he's told you that, right?
Right.
Did you give him a solution for how to fix that problem?
Yes, he has the visitation center's information. I sent that to him back whenever it was granted in December. And I reiterated that he does have it. He can visit Hilly. He just has to go to the visitation center. They has to be supervised, and he doesn't have a place.
Okay, is it your wish that he is able to fix whatever issues he has going on in his life and he's able to be present for Hilly as a parent?
Yes, I do wish for him to, to do what a parent does.
Okay. Until that happens, do you have, oh, actually, Judge, I asked that text message be introduced as ad-litem's number 1.
All right, then I'm gonna ask that cumulatively, all these text messages and information are now marked as at item 1. Any objection to the court having this information, Ms. Campbell?
No,
As
sir.
evidence? Any objection, Ms. Bexler?
No, Your Honor.
All right, and item 1 is admitted.
Thank you, Judge. So are you asking for to be named sole managing conservator?
Yes, I am.
You and I have discussed like what the differences between the two are. Do you have some concerns because of the drug issues dealing with the right to make medical decisions and things like that?
Yes.
Do you also have concerns about him being able to make financial decisions due to some issues he's had with his family over finances?
Yes.
As far as, and so are you asking for this to be, so sole managing either without a geographic restriction or at least a broader geographic restriction than what you have on temporary orders?
I like non-geographical, but either if I just the whole state of Texas, that would be open.
Okay.
I'll grant the whole state of Texas, man. I'll be good. Yeah, you need. You can't find it in Texas. You can't find it anywhere. Well, I won't go that far, but still, we don't have Disney World yet, so we got to work on that. So, or Harry Potter, so we're good.
Yes, Your Honor. So and you don't have any plans to move right now, but you're in the nursing field, right?
Yes, ma'am.
And so there's a chance that, there could be a better job just down the road, right?
Yes, ma'am.
Okay. And up to this point, you have not been receiving support, correct, for Hilly?
Correct.
Okay. So you need to be able to go to different places to be able to have gainful employment and take care of your kid, right?
Yes, ma'am.
Okay, as far as visitation goes, it originally started with that July hearing. It started with supervised visitation at his mother, at the paternal grandmother's house, correct?
Yes.
And that is no longer an option at this point, correct?
Correct.
Did he and his mother have a falling out and he is no longer welcome in her home?
Yes.
So we had to find a different supervisor, and his father is not really an option either due to some health issues, correct?
Correct.
So we did not have a supervisor who could basically take care of the supervised visitation, correct? You couldn't think of someone who could do that, right?
Correct.
So we, at the last hearing, changed it to Unity Supervision Center. And are you asking the court to take that same visitation from that order and make it the final order?
Yes.
If you can find a different supervisor, let's say that he repairs his relationship with his mother and she's able to do that. Would you allow that type of supervision at your discretion?
Yes, yes.
Okay. I think we've already covered the issue of non-disclosure. Do you have some concerns with him knowing where you live?
Yes. But
The
he knows where I live now. But
I'll
But
tell you
if
what,
you
ad litem number one, while not totally threatening, it was threatening enough. I'll go with that. All right, you don't have to go into any detail. It was threatening enough, and it was also a little, it was threatening and concerning. So you may proceed.
Thank you, Judge. As far as being able to reach him by text or anything like that, you and I have discussed other options, but you've decided you're okay with still providing a cell phone number for him to be able to communicate with you by text, right?
I don't like it, but yes.
And that's because, is that because of the reality of, we talked about app close, and if it's going to where it's going to cost another $9, $10 a month, you'd rather avoid that monthly expense.
Right. And I don't even know if he'd even download it, period, or if that would even stop the abusive text messages that he sends to me.
So do you feel that he will still send you text messages regardless?
Yes.
Okay. Can you think of any other concerns? I think we've covered all of it. Can you think of anything else that you wanted to request for the court that we have not covered?
I've just brought it up about just the abusive text messages. I just don't know what to do on my part, other than just, I guess, keep receiving them. I know that the police said I could file a restraining order because of his threatening text messages, but I didn't know, if that's going to go against me if he wanted to see her for a supervised visit, that kind of thing.
Okay. Well, it's not currently before the court. You have, the ability to request, a protective order or a restraining order or something like that based upon threats of violence. So that's something that you could, consult with counsel on and decide if you want to file something. It can create some issues on the supervised part of it, but if you're going to a place like Unity Supervision Center, you're able to drop her off at the center, and it's the visitation takes place in a safe setting without you having to be there physically with him. So
Yes.
that appears that would at least fix that situation. Can you think of anything else that you need to bring up to the court?
Not that I can think we've.
And I know I'm putting this on you, but I think I've covered everything on my list, and I'm not sure if I'm leaving you, since you are I'm not your attorney, that there's anything that you wanted to bring up, but I'll pass the witness, Judge.
All right, then, Ms. Campbell, obviously, like I said, Ms. Kuzak represented the child's best interest in this. I'm looking at naming you the sole MC, giving you the right to decide domicile, giving you the right to decide domicile within the state of Texas. I'll go ahead, and that means anywhere in the state of Texas, even in the Western time zone, if you need to move out to the military facilities in El Paso, whatever's necessary. I'll go ahead and grant the guideline child support going forward. I'm going to grant the retroactive and the repayment. Hopefully, you'll start getting money from this person someday. But right now, I am going to find that based on his behavior in the past and his not doing the drug test, that it's in the best interest going forward that he be named a possessory conservator. I'm going to limit his rights under possessory conservatorship to the ones that allow him to have the obligation to pay child support and the right to have visitation, but that visitation is either at the visitation center that he sets up and pays for everything to get it done. If we'll give him mom proper notice, and or unless she found someone else that we willing to sit with him and the child and she feels safe with. Otherwise, that's it. I'm gonna go ahead and, like I said, order him to pay court costs if it's available. If the county bills it, I'll go ahead and order him to repay that only before the 31st day of December of this year if he gets billed. And I think that's pretty much it.
Your Honor, I just wanted to
I'm getting ready to
say-
I was getting ready to come back to you, but I was gonna let her know that's what I'm looking at doing, and then I want to ask her, is there anything else she wanted me to add? So don't worry, I was gonna get back to you too eventually. All right, so ma'am, but based on what I just went over, is there anything else you can think of that you want me to add that wasn't covered by what I said and what the ad litem said?
No, sir, I think we've covered it.
All right, then. Ms. Bexley, you had something else, please?
I'm sorry, Your Honor. I thought that you were doing your ruling. I'll
No, I was
stop
just telling her what
interrupting.
I was looking at, but and
Yes,
after
Your
it's all
Honor.
said and done, I'm gonna say that's my ruling. Okay, so yeah.
Oh, okay then. So the retroactive total, I got $8,120 based off of minimum wage, Your Honor.
Okay,
And then
see, I
the
was
repayment
thinking
would
you
have
already
been
went over that, but that was the last case. Sorry about that. Go ahead.
the repayment would have been $91 per month starting March the 1st, 2026. And I wanted to make sure that the child support was $221 starting July the 1st, 2025, which was what was in the temporary order. And the medical support was $57 starting July the 1st, 2025. So I wanted to do that so that the retroactive was cut off at that point.
Yes, sir. All right.
Okay.
All right, duly noted. Anything else?
So I'm to repeat what was in the temporary order as far as the locations of the exchanges at the visitation center.
Yes, ma'am, you are. And again, give her the option if she finds someone that's the two options are visitation center or another visitation center that she's okay with, and or if she finds a third party she feels safe with, that she and he by agreement can do that as far as, but it has to be restricted visitation no matter what. All right, with someone there to be safe for the safety of the child because of the failure to comply with the drug testing request.
Does he need to give notice by a certain time, Your Honor?
Anytime he wants visitation, he's got to give her at least 72 hours advance notice I'm sorry, let's go ahead and make this a little easier. Let's go ahead. He's got to give her at least 7 days advance notice of the center being booked and all that. That way she can make plans. And it won't be a last minute deal. Anything else other than him booking the center himself to set up visitation, like I said, can be done with 72 hours advance notice. But the center one has to be at least the current center or a new center has to be at least 7 days in advance.
Is there a certain date or time, Your Honor, for the visits?
I'll give it, since I give it, it has to be on the weekend, and it has to be it has to be, it needs to be on a Saturday or Sunday, but it has to be in compliance with the hours of the center. And mom's in agreement for it to be another date, that's fine. But he's still, no matter what the date is, it's got to be at least he has to give her at least 7 days advance notice that he's already paid for it, and confirm that with a copy of the receipt so she can confirm that with the center that it has been reserved and paid for.
Yes, Your Honor.
And Judge, if I can add, the temporary orders from before had the periods of supervision or supervised possession shall occur on the 1st, 3rd, and 5th Saturdays of each month from 1 until 3.
Okay.
Does that
All right,
sound
then.
something?
Okay, we're going to leave that as is then, but but again, he has to get if that's the way it's going to be set up, then I'll just still put it 7 days advance notice for a visitation center. Any other visitations, 72 hours advance notice. All right. Okay.
Thank you, Judge.
So 72 hours advance notice, Your Honor, and not
That's
7?
72 hours advance notice and anything other than the visitation center. Because there's two different packages. There's a visitation center is spelled out, visitation center that they both agree to. That's the 7 day one. Any the other visitation where she gets to pick a third party to do it if she feels safe with. Once he has to give her 72 hours advance notice that he's requesting that visitation, and that way she can set it up.
Like if grandma's watching or something.
Yeah, he prepares with grandma. There's another family member other than dad who obviously I understand doesn't have the health to do that. So yeah.
but it's not going to state or like it's going to be if mom
Yeah, that's at your sole discretion, ma'am.
Okay, I just wanted to make sure like whenever he reads it, so it's not like another, that it's
No,
clear
no.
as day.
That's
That
that part is at your sole discretion. The other that part of picking a second care center is also at your sole discretion by agreement. But the first one is if he gives you 72 hours and he shows you that he's already paid it and it's set up for that next coming Saturday, 7 days out from that 7 days out from that next Saturday, and he sends you the receipt and you can confirm, then you have the child there for that visitation. All right.
Yes, sir. Thank you.
All right. Anything else, Ms. Bethlyn?
No, Your Honor.
All right. Anything else on this one, Ms. Kuzak?
No, sir. Thank you.
All right, Ms. Campbell. Anything else? Any questions, ma'am?
No, sir.
All right. I'm gonna let the state prepare that order and circulate it to you and the Adelaide. Is there anything else you wish to have the court deal with or rule on at this time, Ms. Kuzak?
No, Your Honor. Thank you.
All right, then. May Ms. Campbell be excused, or do you want to back and break out to go ahead and give her an order that she can look at and sign off on today, or is she free to go at this time?
Breakout, Your Honor.
All right, then. All right, then. I'll let you go back in there. I'll let Ms. Kuzak wants to go back. She can go back. She wants to leave. She can leave. Obviously, the lawyers are a little different. So, but anyway, at least you get this by Ms. Campbell and then send it over to Ms. Kuzak at her discretion, and she'll get it right back. All right. Thank you, ladies, very much. Everybody be safe out there, and we're off the record. Thank you.
Thank you, Your Honor.
Thank you, Judge.
Thank you.